This is Bruce Kettler, Director for the Indiana State Department of Agriculture. Welcome to the informational webinar for the Indiana Grain Buyers and Warehouse Licensing Agency. We appreciate your attendance. I'll start out with the first slide that talks about we have to show a disclaimer. It says the information and resources provided herein are for informational purposes only and should strictly be considered a supplemental source of reference. None of the information and resources outlined, explained, or defined within this presentation shall supersede any state or federal laws. This presentation shall not be construed as legal advice. Again, thank you for being on the webinar. We appreciate your attendance and willingness to attend and get the information. We're going to start out by talking a little bit about the Grain Buyers and Warehouse Licensing Agency. Very often it's referred to as the Grain Buyers Agency. I want to start first by talking about what the agency is, how it came into existence. It was established in 1975 after the collapse of a commercial grain company that really ended up with a lot of farmers not being able to be paid for what the grain was delivered to an elevator. So it's been around as an agency for a lot of years. We are serving as a regulatory unit of state government, mentioned earlier, located within the State Department of Agriculture. In fact, this agency is the only regulatory piece of the State Department of Agriculture. So it's unique in that manner. The agency is responsible to conduct financial and inventory audits on commercial grain operations that operate within the state of Indiana. And I'll note that, there are a couple of different sections of audits that are done for those entities. As you can see, it has the oversight of about 220 licensees. Those licensees in the state of Indiana have about 400 different facilities across the state. And I think it's important to point out that when we talk about a licensee, it's not just the commercial elevators that most of you are familiar with. A licensee can also be an ethanol plant. It can be a feed producer. Essentially, we're looking for folks that are the first purchasers of grain, of certain amounts of grain, essentially 50,000 bushels or more, directly from farmers and producers that are the licensees. And so, again, it can be elevators, ethanol plants, feed mills. Those are the folks that are licensees and are people that are grain buyers, and warehouse licensing agency is responsible to regulate and to audit. The second part of this equation, there really are two separate entities. We've talked about the Grain Buyers Agency. Then there's also the Indiana Grain Indemnity Program. And again, as you can see, this was established by the General Assembly in 1995. And it was an effort to be able to protect grain farmers, grain producers, and provide them protections from catastrophic financial losses. And that's really important to know. So if there's a licensed grain bank, grain buyer, or a warehouse failure in the state of Indiana, this indemnity program or fund is there to protect our farmers from catastrophic losses. You'll also notice that the indemnity program is 100% funded by premiums that are collected from grain producers when they marketed their bushels to any of those licensed entities during an active collection period. And the most recent active collection period started in July of 2015. It ended in July of 2017. And I will also note we've only had two collection periods since the fund has been in place. We've only had two collection periods in the state of Indiana since 1995. The premiums that are collected through what the farmers contribute go to the indemnity program, but it is really important to note that those premiums can only be used to reimburse farmers that are negatively impacted. In other words, the premiums that are collected that are in the indemnity fund are not used for the operations of the Grain Buyers and Warehouse Licensing Agency. And that's a little different than in some other states. But the funds that are in the indemnity program are only used and only able to be contributed to the producers that put money into the fund. Continuing on the grain indemnity program, question about who may administer the indemnity fund. There is actually a board of directors known as the Indiana Grain Indemnity Corporation. You might hear it referred to as IGIC, but that is its own and separate corporation. And it's important to note that this board of directors is made up of 10 voting and 3 non-voting members. In other words, 13 total members on the board. Of those voting members, I want to give you a breakdown so you understand who all is represented on this board. We've got 2 from the Indiana banking industry, 2 from Indiana's commercial grain and feed industry, 1 is from the commercial seed industry, and 5 of the voting members of the 10 voting members are Indiana farmers. So half of the voting members of the board are, and this is required by state law, half of those voting members have to be farmers that are represented on our board. There's been a number of questions about the indemnity fund and how much money is contained. As of the end of April, which are the last and latest numbers that we have, the indemnity fund in Indiana has over $36 million in cash and is invested. The investments are handled by the state of Indiana through the state treasurer's office. But the indemnity fund in Indiana sits currently at over $36 million. Been a number of questions, obviously, about collection period. The most recent collection period started in July of 2015, and it remained active until July of 2017. So that was the last collection period. And I'll just note, since the fund was started, as we mentioned, in 1995, there have only been 2 collection periods in the entire history since 1995 of the grain indemnity program. Okay, so I know that there are lots of questions. A number of questions have been received about why am I only receiving 80% of what I put into the fund versus 100%. So we thought it was really important to provide a really good example of the collection, because if you want to think of the indemnity fund kind of like insurance, it's like paying premiums, and in fact that's what we refer to it as. So I'm going to turn it over to Harry Wilmoth. Again, Harry is the director for the Grain Buyers and Warehouse Licensing Agency. He's going to run through a real quick and simple example of the premiums that would have been paid in, so that you get a sense of those that will receive money back out of the indemnity fund, what that looks like. Again, a real quick question for those that are on the webinar, you can see at the bottom of the screen, but those that are on the phone, if you want to text a question to us, the number to text a question is 317-760-4669. Harry, I'll turn it over to you to go through this example.
Yes, no, thank you, Bruce. Good morning, everybody. My name is Harry Wilmoth. I'm the director of the Indiana Grain Buyers and Warehouse Licensing Agency. As Bruce already said, this is just an example we put together to help kind of show the calculation of a potential farmer doing 1,000-acre operation of a standard rotation of corn, beans, and wheat in the state of Indiana, just to show how much potential money that was collected from a farmer of this size in their producer premiums. So what we have used is for the 15-16 crop year and the 16-17 crop years, when the last collection period was actually in effect, the USDA Statistical Services reported that the average harvested bushels in the state of Indiana, and we take that and using the average marketing year price to help determine the producer premium amount. So it's really important to remember that in law, the producer premium amount is defined as 0.2% of the price of all marketed grain. This price is calculated using the gross sales price. It includes all premiums and discounts for moisture, damage, quality of grain, variety, and anything that really is the characteristic of the grain itself. The premium is calculated, though, before any deductions of marketing assessments, storage costs, drying fees, cleaning, anything of those extra additional services that would be attached to delivered grain. Like I said, with that premium, again, if you just take the average harvested bushels per acre in the state of Indiana for each of the 2 crop years, and the average reported marketing year dollar price, a farmer of about 1,000 acres with a standard rotation of corn, beans, and wheat, you're looking at a collective total of about $2,362 is what the total premium of a farmer of this size would actually contribute to the indemnity fund. So when you talk about um, that situation, that's really how much a producer paid in. For this collection period, again, collection period started in July of 2015 and it ran until July of 2017. So of that 2-year span, again, a farmer of this 1,000 acres type of operation is looking at paying just over $2,300 in the premium amount that was all compiled and contributed to the overall fund.
Thanks, Harry. Very, very good example, and again, hopefully simple to be able to calculate. Obviously, your individual farms would have been slightly different, but I hope that gives you a sense of the contribution that would have been made. So again, as we think about some of the questions that we've received and continue to receive, just first, for people to understand who's covered under the grain indemnity program. That's a very common question, but basically anybody during that collection period, again, the last collection period was in 15 through 17, July of those years, a grain producer that, as long as they didn't request to receive a refund, and there is an option to receive a refund in the law, but for those that did not, they are considered to be active participants in the indemnity program. And we have had a question or two, hey, I've just started to farm since the last collection period and have contributed grain, have grain stored. Am I eligible? And the answer is yes. So even if a new farmer never paid a premium into the collection period, but are actively farming and in a situation they can. So then the question becomes, what is covered? Because as you all know, there are lots of different options when you deliver grain as to how you can market your grain or store it. And this is really important. So if it's to a licensee, whether it's a grain bank, grain buyer, warehouse facility, whatever, the grain delivered in these situations is covered under the grain indemnity program. If it's put on grain bank, if it's on open storage, if there are warehouse receipts, maybe you had deferred pricing, you've got fully priced contracts or basis contracts, it's covered. In some cases might be a hold pay, or if there in fact were return checks, then those that are in those situations with grain delivered under those situations are covered under the grain indemnity program. What's the duration of the coverage? So this is again a common question we've had a time or two. Grain that has been delivered not more than 15 months before the date of the failure of a facility is considered into the program. So 15 months prior to the date of the failure, grain that has been delivered into a facility that has failed at that stage is eligible. This is in Indiana code. This was put in the 15-month time frame was put in statute by the legislature. It's also important to know that actual physical delivery date of the grain is what needs to be considered for eligibility. That's really critical and key to this duration of coverage. Then a lot of people have had questions about what is eligible for reimbursement. Again, it can be bushels that are on grain bank, open storage, or if you've got warehouse receipts. Those situations are eligible for 100% of their determined value. And again, back to Harry's example, and similar to what when we collect, less any and all charges, discounts, premiums, and funds that go into the state corn and soybean checkoffs, that's also it. So if it's on grain bank, open storage, warehouse receipts, it gets reimbursed at 100% of that determined value. In contrast, bushels that are on deferred pricing, fully priced contracts, basis contracts, hold pay, or a return check, those situations are reimbursed at 80% of the determined value. And again, less charges for discounts, premiums, and the checkoff. It's important to keep in mind this distinction between 180%, depending upon your particular situation, to know why there might be a difference. And again, I want to point out both the duration of coverage and what is eligible for reimbursement is set up in Indiana code, and that's pretty important to do. Okay, so a lot of questions. We're going to move in now specifically to Salamonie Mills and AgLand Grain. I'm going to turn it back over to Harry to talk a little bit about the process because, again, I know a lot of folks have some questions about what this process looks like. Harry?
Yes, no, sir. Thank you. So just jumping into the claims process, this is just, we broke it down into a few simple steps just to highlight the major milestones that we're looking to achieve as we continue to move forward here. First, what we kind of labeled step one would be your information packets. We as the agency will send out these full information packets to all of the people we have identified that is potentially impacted by either the Salamonie Mills or AgLand Grain closures. You will receive these packets via USPS first class mail. I know over the past couple of months, we've had a lot of people reach out to us. And when we talk to you, we look to verify your name, if you have a farm name, contact information. So if you haven't contacted us yet to verify your contact information, that would actually be really, really helpful. Feel free to email it to that IN Grain Buyers email address, or feel free to give us a call at the area code 317-232-1360. And that way, it's just really helpful. We verify the mailing address so we can get you all of this information as soon as we possibly can. Now, when you actually get those packets, your packets will include specific and unique documents that are, again, specific for you as an individual. Those documents are going to itemize the agency's preliminary findings based on what we get from the company records. When we talk about doing our reconciliation of company records, because a part of that step and our responsibility is to provide, impacted producers with good information to help them make the decisions they need to in about filing their claim. So in your information packets, there'll be just a simple introduction letter letting you know what it is and kind of what's going on at the time. What we call a proof of loss statement. This is more of that high level document that totals the total bushels and total dollar amounts that you'll actually have to sign and submit to with your claim. It will have a grain invoice. This grain invoice will break down line item by line item your individual tickets and positions that we show that you're still owed for in some capacity. Again, grain bank storage, deferred pricing, or a contract. It's all broken down on that grain invoice so you can see what we see. If on that grain invoice that there is something missing, then that's where you really need to review this packet, and so you can communicate better with us what it is that's missing. You'll also have a lien holder verification form. If farmers like yourselves here have any type of loans through the CCC, a local financial institution of some kind, this lien holder verification form needs to be filled out so we can be on notice with you as the claimant and help you be sure that we're paying not only you but your lenders properly and not cause any confusion or concern between you and your lenders. Contact information verification form that literally is just we're saying, hey, this is the information we have that's best to reach you. Please confirm this. And if it's not the best information, there's a place for you to update it and get it back to us just so we can keep that good information on you guys to be sure we're getting you stuff in a timely manner. If we send something to the wrong address, I'm sad to say it takes a little bit longer to come back to my office, and then we have to kind of figure out what to do. So just verifying your contact information helps the agency keep things moving a lot faster. And of course, there'll be more FAQs that are related to you submitting the claim and the documents in your hand. These packets will also include information as we lead into step 2, which is the next step for the claims hearing. We'll talk about that in just a minute. When you get your packets, please review them thoroughly. If you think there is an error in your preliminary documents, and I do emphasize the word preliminary, it does not mean it's final. It's just your way to look if there's an error and prepare. So, if there's something wrong, get your stuff in order to show us how we can maybe help you fix it. On your individual proofs of loss statements, you're going to be asked if you agree or disagree with the agency's preliminary findings. If you agree, that's great. We can kind of keep moving forward with you. However, if you disagree with what we say, that is perfectly all right. Part of the reason that the agency has to go through this process is to enable producers who may have been affected by these grain closures to have time to review, collect, and submit their documents. Once the packets are sent out, approximately 2 weeks in those packets, you'll have the confirmed date. You'll be looking for the agency to actually have that claims hearing. Again, it's perfectly to disagree with your preliminary documents. The claims hearing is an opportunity for everyone to come forward and submit additional evidence to help support their individual claim. Please remember, if you disagree with the documents, that's good, that's okay. But the burden of proof to justify, changing that information does fall on you guys as a claimant. If you have tickets, contracts, bills of lading, anything along those lines that you can help justify the claim in a better way, please get those copies to us. You please keep the original documents, just give us copies. So those documents are always in your possession as well. Once the claims hearings have concluded, the agency must allow for another 2 weeks after the hearings for individuals to actually file and submit their claims and collect whatever additional evidence they need to help justify their claim if they wish for something else to change. Next slide, please. Once the claims hearing's done and the 2-week window has closed, the agency will work to issue what's called a findings of fact and final order. This order is basically the final decision that the agency is issuing on its findings from company records and submitted evidence. The order will be mailed out to everybody listed in it so you can see what the agency has officially decided for your potential claim. Again, if you disagree with the order, this is another opportunity for producers impacted here to disagree and continue to submit evidence disagreeing with that order. Evidence submitted disagreeing with the order, we do submit that on to a third party, what's called administrative law judge, for their further review. They are somebody who would be new to the situation, who has not looked at the documents before, and would get to issue their opinion on the matter. Once the order is issued, farmers have 18 days after the order is issued to submit those following claims. If you agree with the order, then there is nothing else for you to do. We just have to let the 18 days go by, and then we can move on to the next step. But that 18 days is very important if you guys disagree with what the agency has issued as its final decision. Once the 18 days of the order has passed, the agency can start moving forward with creating payments. All proven claimants identified in the order who did not submit a petition challenging the order, we can begin processing their payments. Again, if you disagree with the order, that's perfectly okay. You do need to make the decisions that are best for you and your farming operation. The agency will not have any negative implications on people that disagree. We'll gladly continue to work with you and help get set up with an innocent third-party administrative law judge. However, if there are challenges, the agency will be able to move forward with partial payments. So just because one person agreed and another person disagreed, perfectly okay. We will just move forward with partial payments. We try to afford as much of the partial payments as we possibly can for everybody who agrees, while we still continue to work with the other people who need to continue substantiating their claim. If necessary, once this is done, if we have to go to the indemnity program, the agency will automatically forward on all of the remaining unpaid claims to the indemnity corporation to go that reimbursement route. Timeline here, a little more historical. Just to reiterate, on March 3rd, the agency did serve a 20-day license suspension to both Salamonie Mills and AgLand Grain. The agency was working with both companies to address certain concerns that did come up. As the agency was continuing to work with both companies, it did have to serve another license suspension on March 20th. And then as things continued, by March 24th came around, both companies voluntarily surrendered their license to the agency. So that's just kind of the historical timeline that went through.
So, Harry, I think it's important to note for farmers here that there are actually, let's reinforce, there are two entities here, and thus we've got two different timelines that will be on. So if someone is with one versus the other, they'll be on different timelines, and we've got that laid out and starting here at the next slide.
Yes, thank you, Bruce. Like I said, they are separate companies, separate licensees, so we will have to treat them separately. Again, with AgLand Grain, right now we're currently working to have all the information packets mailed out by June 17th, with the intent to have our claims hearings around July 2nd. The agency, we must secure a venue that is large enough for all of the attendees to respect the social distancing recommendations that are in place here with COVID-19. I'll just go ahead and say it now. Anyone attending the AgLand Grain claims hearings will be required to follow the social distancing recommendations. Simple things would be, we'll have enough space for you guys to sit far enough apart, as well as something covering your mouth and nose during the entire session. Going to Salamonie Mills, right now the agency is still processing all of the company records. As it was a larger company, there is significantly more information that we must continue to process. Right now, we don't have an estimated timeline. Our current goal is to hold the claims hearing for claims hearing. So this information packet's been sent, and the actual claims hearing, jumping to step 2, would be have that by the 1st of August. A lot of the questions that we have been asked, farmers wanting to know the price of grain. These right here will be your prices. If you had a basis only contract, your May 2020 futures will be used, and you're looking at 3.43 3/4 cents for corn, 8.62 1/2 for soybeans, 5.39 1/4 for wheat, and 2.62 for anybody that had oats. With the futures values, we will not be rounding those because those are what the May 2020 futures closed on March 20th at 2020. That would be for the futures value. The cash price that will be used for any storage, grain bank, deferred pricing grain. The cash price for corn is set at $3.41. Soybeans will be $8.64. Wheat is $5.32, and oats will be $3.09. These are the prices set, and then any discounts, storage fees, service charges, checkoff, premiums will then be reduced from these dollar amounts accordingly.
Thanks, Harry. Appreciate that update, and I know that's answered a lot of questions for a lot of people. Again, just a real quick reminder, if you have questions, we are receiving a lot of questions from text. The number is 317-760-4669. So we appreciate that. We'll put up on the screen for those that are on the webinar, you got information to contact both ISDA and the Grain Buyers Warehouse Licensing Agency. As Harry mentioned, if you want a phone call, you need to talk to somebody in Grain Buyers. That phone number is 317-232-1360. 317-232-1360 gets us into the Grain Buyers and Warehouse Licensing Agency. Okay. We, as I mentioned, have received, actually prior to the webinar, we received some questions on email. We've received a lot of questions on text as we've been on, and we appreciate that. Thank you for doing so. So we're going to go ahead for a few minutes here and review some of these questions and answer the questions that we have. And again, thank you for your interest in being able to do that and send that information in. So Harry, I'll turn it over to you to talk about some questions.
Yes, for a second. We did receive some questions. People did submit them before, just to add some dynamics. So I think, Bruce, maybe if you can read these questions to me, and I'll provide the answer for people to follow.
Yeah. So we'll start with this. Will grain delivered to a third-party destination by a producer that sent to AgLand Grain or Salamonie Mills, will those folks be included in any preliminary claim?
Yeah, so if a producer actually delivers grain to a third-party destination like a bean crush or ethanol plant in AgLand Grain or Salamonie Mills' name, and that producer was waiting to get paid from either company, those bushels should be identified in that producer's grain invoice that they will receive from the agency. So yes, those producers, you should see those. If you don't, please start gathering those tickets and bring that to our attention through the claims hearing process.
Another common question we had, I think we answered it a little bit ago, was how will the price of grain for delivered bushels be determined? And that was that list that Harry went through. Depending upon whether it's based upon futures price or cash price, I think we've answered that question, and we'll go with that. Another common question. Some folks had grain in these facilities. Why can't producers get the grain that they had in the facility?
Yeah, that's twofold. So the agency was actually unable to guarantee the quality of grain just because we don't run elevators necessarily. So producers with the grain bank or open storage, they will not receive their grain back, but we will process them through the claims process accordingly. If the producer had grain delivered on a contract or deferred pricing, that will also go through the claims process as titleship of the grain was transferred to the company at time of delivery.
Okay, thank you. Some folks have want to know when was the previous audit of AgLand and or Salamonie?
As disclosure laws, so disclosure laws only allows the agency to really divulge certain information. Although I may not comment on any one specific companies that we license audits, I can say the agency's process is to conduct audits on all of its licensees at least once a year.
Good. Another question we had, this is somebody that's looking at things pretty closely, I would say. What's the difference between a license being surrendered and a license that's being revoked? Okay. Difference between a license surrendered versus revocation of a license.
When a grain license is surrendered, that the holder of that license is actually giving it back to the agency voluntarily. When the grain license itself is revoked, that's the agency making the decision to take the license away from the holder of it.
Okay, good. Okay, question has been asked. During a routine audit, what information is verified or calculated during a routine audit?
Yeah, so during a routine audit, the information we collect is really conducting reviews on company financials and inventory information. There are similar benchmarks that the agency looks for when it looks at all of its licensees in general. However, based on the company's model, unique characteristics may also be included. So something simple may be like, well, a feed mill versus a grain elevator. And then if you take that country elevator, it would be different from an actual ethanol plant or bean crush.
And I think it's important to point out there, Harry, the auditors and folks on your team, when you talk about actually verifying bushels, they climb bins. They actually do calculations and measurements on the physical inventory that's in a facility.
Yes, no, climbing to the top, lasers, old-fashioned measuring tapes, all of it.
Yep, it's good, important to know. Okay, if a licensee were unable to meet its loan obligations or to pay producers for the grain obligations, how does that get communicated to the agency?
Okay, yeah. So first, the agency receives company information. It does not have access really to a bank's records. Therefore, financial institutions are not legally able to share that information with us. Second, if producers themselves are not being paid in a timely manner, again, their high recommendation is they need to contact the agency as soon as possible. When they call us, they're not trying to tattle on anybody. You're expressing a real concern, and simple things like that. If we can get in front of it sooner rather than later, helps things go a lot smoother.
Well, and that's an important point. I want to also mention to anybody that's on the call and listening is especially for farmers. If you've got questions, you've got concerns about what's going on, maybe you're seeing some slow pay or something, you really do need to contact the Grain Buyers and Warehouse Licensing Agency. That's what our team is here for. Uh, I understand a lot of people in the farm community say, "Hey, I don't want to tattle on somebody. I don't want to create any problems or issues." I get that. I fully understand that. But at the same time, what I think is really important to remember is you may be one farmer that has an issue, but if our agency is hearing from multiple farmers, multiple people within the community that there are problems at a certain licensee, that tells us and gives us good information.
Mm-hmm.
And it's really important that everybody be able to share that. It doesn't always mean there's a big problem.
Yep.
There might be legitimate reasons for it. You've had situations where somebody thought that they didn't get paid for something, and lo and behold, they found out the check fell behind the file cabinet, right?
Yeah.
So it's really important. It may be a simple explanation, but it also allows the agency, if there are multiple things happening and they're hearing consistently from others, they need to make sure that they contact your team. I think it's important to do.
Yeah, no, just to reaffirm that, if people call us, just some reassurance, one phone call from you, we do not go in guns blazing.
Right.
Like you said, a lot of times it's simple mishaps. So just to encourage people to contact us.
All right, another question we got on text message. Have the surety bonds been called?
So all of our licensees are required to have certain surety bond levels with the agency. The agency is working to call on that surety bond, in which that money will be used to help compensate farmers impacted here as well.
Okay. All right, another question says a grain buyer has to have a bond to have a grain license. What is the bond for? Why isn't there any money available from the
bond? So yes, a grain buyer
or a licensee.
A licensee. Yeah, all licensees issued, whether it's a warehouse, feed mill, grain buyer, are required to have certain levels of surety bonds as defined by law. So like I said, we are in the process of calling on the respective bonds for each company. We will do that for you guys as farmers. The farmers don't have to call on the bonds. We do that to collect what I call the hard cash that will then be made available accordingly to producers impacted.
Okay, good. All right. Are there going to be virtual ways to watch hearings? Interesting how times change pretty quickly, but in these claims hearings that you talked about, will they be available virtually?
Yes. We are working for the claims hearings. COVID-19 has presented us with some new challenges. Our goal is to be able to stream all of the claims hearings through their entirety. People so they could log online and watch them, hear them one way or another. And if you can do that, you don't have to attend a claims hearing to file your claim. So if you are someone who needs to stay home, and for whatever reason that may be with COVID-19, you can listen to the hearing. You can still file all your claim and all of your supporting evidence via mail. You can call us and we'll work with you. The claims hearing, though, is just a good way to get your expressions and things that need to be addressed on the record.
Good. What percentage of the payout will come from the bond at 100%, and what percentage will come from the indemnity fund at 80%?
It's really difficult to answer that question, the question specifically as it is right now, just because the claims have not been closed. So who's owed what is still things we have to determine. But the way the process works, addressing the 100 versus 80, the cash we can collect from a bond and the cash we can collect from what grain we're able to liquidate, that gets distributed accordingly. And as long as we can continue distributing that cash around and around to farmers, that increases the more you would get over 80%. The 80% comes into play once it goes over to IGIG. So a quick example, if you lost $1,000 and I give you $100 from the collections of grain sales and bond, then we send the $900 remaining over to the indemnity fund, in which the 900 is the 80%.
Okay. Again, that helps to understand that distinction between the grain buyers warehouse licensing agency and the grain indemnity fund or the IGBWLA board. They're two different entities, so that helps with that. Okay. I'm wondering why there is only the 80% of return on the value of what is received. I think referring to if I have grain in the facility, why do I only get 80% of the value?
Yeah, that goes back. It's kind of like insurance. When we talked about the producer premium example earlier in the slide versus what producers are paying in, that's kind of your deductible, that's the premium. Some people like to refer to the 20% as the deductible. It's not necessarily apples for apples, but the 80% is part of that process.
Okay, good. Question is, what led to the audit, and who started the audit?
So we'll say what led to the audit. It's a routine situation. Like I said, we audit all of our licensees at least once a year. So that's part of the process in general and responsibilities of the agency. Who started it? Well, the Indiana Grain Buyers Warehouse Licensing Agency. Our responsibilities and mission statement, day in and day out, we go to these places to do the audits, as many as we think we need to do to ensure stability.
Good. Okay, another question texted to us. With the recent financial stress in the ethanol industry, what is the agency doing different in its oversight of such sizable risk at ethanol facilities?
There's been a lot of dynamic market risk, not only with the futures values of grain, but also the value of ethanol margins, and also the supply and demand situation of ethanol, and also goes into fossil fuel. It all feeds into one. These are ever-changing situations. To this person's question, it is very on the forefront of the agency's mind right now. I am very grateful that here in Indiana, our ethanol companies are very kind to us. They're very forthcoming with us. So again, having that good relationship. So if we need to see them, audit them, those are all options we have on the table as we continue to watch that matter a little closer. But no, I said we don't necessarily influence ethanol's decisions.
And I'll go back to what we talked about a little bit earlier, Harry. Our ethanol facilities are part of the audit process in the state of Indiana. You may know this differently than I. I'm not sure that's the case in every state. Actually, the important thing for a lot of our farmers in Indiana to understand is not every state has the sizable indemnity fund that we do in Indiana. In fact, some states don't have much at all. You would be very surprised in some of our neighboring states and others in the Midwest how small their indemnity fund is. And so it's important to note ethanol is part of that process in the state of Indiana. I think that's important.
Okay. Just to add that, Bruce is very right. Here in Indiana, we do it one way. Our neighbors, Ohio, Illinois, Michigan, they have their whole set of state laws because these grain buyer agencies and their counterparts are all about the state level and how they address certain concerns and requirements.
That's good. All right, another question that was texted to us. Who gets paid first, the bank or grain buyers? And I'm assuming by grain buyers maybe referring to farmers there.
I say that's assuming the bank or grain producers.
Yes.
There is, like I said, the agency in its position, it does have to show respect to not only within its own internal law, there is a hierarchy in which we have to do first, second, and third rounds of payments. That doesn't mean people third people are out. It's just, yes, there is a priority we have to show respect to. In addition to that, when someone wants to talk about a bank, much like farmers have loans secured through collateral purposes, the agency does have to show respect to liens that have been filed by financial institutions who have lent money to any of its licensees as well.
Good. Another really good question. Will this failure trigger another collection period? We mentioned earlier there have been two collection periods since the fund was started in 1995, most recent being 2015 through 2017. So will this failure trigger another collection period, and what are the trigger levels?
Okay. I'm going to take this question so I can be sure I answer it thoroughly. Where I view our fund balance today, and as I view the two grain closures we're dealing with, I don't believe these two combined grain closures are going to trigger another collection period. That's just where we're at. We still have to go through the entire claims process. That would be my professional opinion. When you talk about triggering levels for a new collection period, this is outlined in statute that we'd have to follow. The indemnity fund will not trigger another collection period until our fund falls below the $20 million minimum. I'm sorry, yeah, minimum. So once we go below 20, we would have to do another collection period. That could be 1 year, that could be 2 or 3. It just depends on how far below 20 we go, back up to 25 million.
And again, that's set in law. That's set in statute
Yes.
in the state of Indiana about that period and the levels that we have to maintain.
Yes.
Yeah. And then there was an additional question that is there a limit of the fund that can be collected, and kind of to that point. Is there an upper end limit during a collection period that we have in the state law?
No, so once we hit 25 million, we're supposed to stop. But the key thing to remember, we have to do it with the full fiscal year. So I'll be very blunt. If we're at, $24,900,000 at the end of the first fiscal year collection period, the indemnity fund must continue into a second year of collections for a full year. Yeah, and it all of it, every penny of it goes into the indemnity fund. If the indemnity fund goes over $25 million, that's fine. Every single cent of that continues to go to the same fund.
This brings up, I think, and we shared a lot of information here, but for those, again, particularly those that are on the phone, I want to encourage you, if you have access or like to be able to get to a website, we have a lot of information about this on our website. Our team here has actually produced a great brochure about grain buyers and warehouse licensing and the indemnity fund, and it goes through the details about some of this information about when collection periods happen and so forth. And if you'd like to have that, please let us know. We'll make sure that we get it to you. So, all right, another question: will bond money be paid to producers to help offset the 20% loss?
If I'm following the train of thought properly, again, the 80% comes into play when we go to the indemnity board to ask to be compensated from that fund. And so, to put it blatantly, then this is just an example. If there was no cash collected, the worst case scenario is 80%. However, the bond and the cash sale that is gained, yes, that would just be added on top, to usually give producers a higher than 80% minimum. Like I said, the worst case scenario is 80%.
And another question related says, is the 80% including the surety bond funds?
No, it is not a flat 80. Again, the 80% only comes into effect once we hit the indemnity fund if necessary. So yes, you could have a few higher percentages. In addition, again, the 80 is the worst percent. I feel like a broken record, but I just don't know how else to say that. So I apologize if you're not quite getting that question answered, give us a shout after this.
Yeah, it's not cut and dried and as simple as
Correct.
We'd like for it to be. But so okay, good. Another question texted to us: since the license was voluntarily surrendered, will either of these companies, referring to Salamonie Mills and AgLand Grain, will either of these companies be allowed to reopen? And then another question, under a different name?
The way the law is written today, I cannot license another company that was part of a previous grain failure. That doesn't mean if somebody else was to come in and want to take those existing assets and run a grain business, that those assets couldn't be used as a grain business in another capacity. But like I said, no, I'm not allowed to relicense a failed company.
Okay. Another question: was it stated AgLand had no bond money? If not, what happened to it?
I don't know where that was stated. I don't know how that
Yeah.
got out. I do apologize that that information has been, tossed around amongst everybody. We are in the process, though, of trying to secure as much money as we possibly can through the bonds for both Salamonie and AgLand.
Good. Okay. I think we're getting close on time and want to be respectful of everyone's time here. So, quick question. Why can't farmers take our 2020 crop futures to our own brokers and be responsible for our own margin calls? We are losing $1 per bushel. So why can't farmers take the 2020 crop futures to their brokers and be responsible for their own margin calls?
I hope I'm answering this correctly to understanding the context.
And I would say if not, they're welcome to contact grain buyers and we can talk specifically.
Correct. So
Yeah.
I have two answers that I hope to address this. First, farmers, of course, in Indiana, you're always more than welcome to have your own brokers and clearinghouses that you as a farmer do business with directly. That is your business and to move forward with, and we don't dictate. There's nothing by law that requires you to do your hedges through a licensed company from where the grain buyers agency stands. In the event, if maybe because the agency does not honor payments for HTAs by law, in the event the agency was able to collect money or is able to collect money from the closed entity, we actually just get the cash, and that cash is then used to be dispersed amongst everybody, part of the payment process of proceeds that are collected. The agency and its responsibilities, no, we are not set up or allowed even. We don't because we don't have our own brokerage accounts or anything like that. That is with the company. Like I said, if we can get that funds from the company to help pay farmers, then we go that route.
Good. Again, want to be respectful of everyone's time. We had scheduled this for an hour. I think we're pushing up against that, and certainly we'll be respectful of that. For those that are on the web, again, we've left the slide up that has the contact information. For those that are on the phone, if you've got questions, additional questions, or want to talk to some of our grain buyers team, phone number 317-232-1360. If you prefer to communicate by email, the email address is ingrainbuyers@ISDA, like Indiana State Department of Agriculture, .in.gov. Okay. If we went over your question in the PowerPoint, we'll not be covering it, but you're welcome to refer back. I want to put a reminder out. We will have the PowerPoint posted to our website. So if you want to go back and review that information, we can do that. Certainly, if you've got other questions, or if we didn't get to a question, you're welcome to contact the agencies. There is, in some cases, we had some questions that we chose not to disclose, quite frankly, because of personal information that could be. So please, I'm going to ask you, contact our grain buyers group. That number, 317-232-1360, or the email is ingrainbuyers, all one word, ingrainbuyers@isda.in.gov. We appreciate your time. Thank you. We certainly understand there's a lot going on. I'm just going to ask everybody, particularly those that are out in the fields, make sure you stay safe as you continue to tend to your crop. We appreciate it. Thank you. Make sure you have a great weekend.